So let's just say you have a brand and your brand is pretty popular. So your brand is being copied by a third party, either for the same kinds of goods and services you're trying to sell or different products and services. What do? So in the US, our system is pretty mature, and especially good faith is built into when somebody files for trademark applications. So they have a pretty mature system to deal with this kind of copycat situation. If it's in Brazil, things are a little bit tough because Brazil and a lot of the countries follow the first to file system. In other words, it does not really matter you're the first one created the brand or you're the first one put that to use. If somebody beat you and record that to the trademark office first, they're considered the brand owner under the system. So of course, then we move on to China. China is the epicenter when it comes to this kind of bad faith applications. So that just spend about 10-11 minutes talk about what can you do, especially China right now has a pretty interesting update about 2 or 3 years ago that is going to have major impacts on US brand owners. So with that, let's go ahead and start. So what does bad faith look like in China? So this is Squid Game, Netflix. Netflix is not even available in China, but within 1 month of Squid Game being released, this is a screenshot I took from the China database. It has already had more than 60 trademark applications for Squid Game. This is ChatGPT. ChatGPT is not available in China, but once again, you see a lot of ChatGPT applications in different products and services, and none of that really belongs to the owner, OpenAI. So bad faith filing is not really impacting you or your client's brand position, the legal position. It actually has an impact for business. So for example, from manufacturing in China to export the products coming back to the US, or you or your client's ability to retail the products and services in China, because you may be deemed as a bad faith owner or infringer to your own brand under the Chinese system. So the impact we're talking here is not just on legal, but it really impacts the business side. So bad faith is not new in China. Since I've been practicing for close to 20 years, deal with that every single day. But what's really new is because something happened in 2022. So 2022, Beijing hosted the Winter Olympics. And overnight, there are a lot of athletes, for example, Eileen Gu, or even Beijing's mascot, Beijing's own mascot, Bin Dun, overnight has more than 1,000 bad faith trademark applications. So of course the central government was upset. China Trademark Office was caught in a hot storm and got a lot of media attention. As a result, there's a reform. So the 2019, there was a reform back then, but it was not effective. 2023, now the amendment is focused specifically on bad faith filings. And there are a lot of things in there because there are proposed over 100 articles. We're going to focus on 3 things. And these 3 things have a pretty major impact and for the US brands. So the first one I'm going to talk about is good news. China finally has a proposed article, Article 22, specifically talk about what are the bases that will make one application as a bad faith application under the Chinese system. So as you can see, if you file a large number of trademarks, or you've got the trademark through deception, or your mark is going to have an adverse impact to the society, it will be considered bad faith. Okay, so good news number 2. This is actually my personal favorite because we're predicting this is going to be the one have the most impact. So what is good news number 2? China, under the amendment, is going to increase the fine 25 times. So in China, it does not really matter you send them a lot of C&D letter, assistant desist letter, legal letter, do a lot of threatening. Unless the things are going to impact the bad guys on bottom line, for example, money, they are not going to take action. So I'm very happy to see they increase the damage ceiling 25 times. In addition, this is not just on paper. We are seeing things across China really focusing on going after the bad faith people. Here are some examples. For example, litigations. These are some of the most recent trademark litigations, infringement litigations. Unlike before, the damage was low. You can see the damage on the right-hand side from $3 million all the way to $11 million. And these are great because these are the numbers that never happened before. But what's even more encouraging is that on the second column, you see the courts handed out these kind of awards are not just the top courts in Beijing and Shanghai, but also second-tier courts from Jiangsu and Zhejiang. So this kind of impact, this kind of determination in going after the bad guys is felt and reflected across different courts in China. And what's really interesting is that we start to see courts are more willing to grant punitive damage. When this proposal came up like 10 years ago, a lot of the people, when I was doing a roadshow, people would say, "What, Amy, is that just a lip service or was that for real?" I'm very happy to report 10 years later, right now we're seeing Chinese courts very willing to grant punitive damage to punish the bad faith people. In fact, in 2023, the percentage of punitive damage went up more than 150%. So what is the result? What is the impact? Before, when it comes to litigation, trademark litigation, when your brand is taken by a third party, most of the people were very hesitant to go to court because even if you got a slam dunk case, the most you can recover is probably $5,000 or $7,000. Honestly, it's not even enough to pay attorneys or people like me. So what's the point of going to court? Now things are a little bit different. Now, like the chart, you can potentially recover from $4 to $11 million. There are punitive damage, there are determination, and it's not just on the top courts where in Beijing and Shanghai, but also different parts. So you have a lot more options. That brings me to the top case that our fabulous team in Beijing just won, and that is the highest damage amount that ever granted to a U.S. brand. That case was finalized September, just last month. We fully expect and we want it to be broken, but let's just look at that. Okay, so this is Weekly's extra chewing gum case. So on the right-hand side, that is the extra brand that I took from Amazon. On the left-hand side, that is the extra brand in Chinese characters. So the bad guy here is using the extra brand on different products. The product here is not chewing gum, it's actually on toothpaste. So if you have a Chinese counsel or if you're a Chinese team, when the bad guy is using your brand but on different products, your Chinese counsel will probably tell you, oh, it's really going to be very tough because of the cross-class protection. But things are different and we just won this case, so that's why I want to highlight this one. So in this case, Weekly fought all the way, but from the invalidation, opposition, rate action, all the way to the Chinese Supreme Court. But the point of these actions is not only to win, of course, it's very important to win, but in each of the decision, we want to have a specific language. That is the bad faith recognition by the courts and different levels across the Chinese Trademark Office of the bad guy. And once we gathered all these bad faith recognition and language, we put them all together and we went after them big time. So the result here is that was the highest damage award ever granted in a trademark case to a U.S. brand, and that was September 2025. That was just affirmed by the Beijing High Court. This is great news. It shows China's determination in going after the bad guy, but we want this case, want the record to be broken. So let's talk about another case. This case was also just recently decided pretty recently, the Estee Lauder. For people who don't know, one Estee Lauder premium body care brand, and that one of the most famous product from Estee Lauder is what's called the little brown bottle, and on the right hand side, this is what the real Estee Lauder product looks like. Now this is what the fake one looks like, pretty similar, huh? So what is the point here? The point here is that the court not only recognized bad faith, but they are willing to pierce the corporate veil and hold the defendants, the bad guys, personally liable. Sometimes people will say, well, Amy, this sounds pretty common. Well, this is pretty common under the US Western system, but piercing the corporate veil and holding the defendants personally liable is actually pretty rare under the Chinese system. So we talk about all the great news. What are the top impacts? What is going to be the bad news for the American brands? One of the bad news is going to impact is some of the strategies that American brands have been put in place for decades, and that is going to have an adverse impact. For example, let me just use Peloton as an example. Full disclosure, we don't represent Peloton, but I'm a personal fan. I'm a huge fan. I own Peloton. I'm in the Peloton workout community every single day, so I'm pretty familiar with the brand. So let's just say Peloton goes to China. What will Peloton register? Peloton's probably going to definitely register Peloton bike in class 28, Peloton shoes, Peloton t-shirt class 25, and Peloton towels. Let's go a little bit crazier. What about Peloton water bottle, Peloton bracelet, Peloton necklace, Peloton yoga mats? Let's push it a little bit further. What about Peloton watch notice? What about energy drinks? even supplements. A lot of people will say, well, Amy, this sounds really crazy because Peloton is definitely, at least not for now, moving to the energy drinks or supplements. But what happened when you go into internationally is that you don't just need to protect the core, the products and services you currently have business plans in, but you also need to protect what's around it, what's something that's related. And that is the strategy most of the American brands, like for example, startup brand to some of the largest brands, that is the strategy that is called the defensive filing. Because when you go to China, Southeast Asia, internationally, its use is not as important as in, for example, when. It's a matter of when your brand is going to be copied. And when you are trying to catch up retroactively, it's going to cost you a lot of money. That is why the defensive filing strategy you file, you spend probably $2,000 rather than $200,000 trying to get your brands back. But what is the impact under this 2023 amendment? The impact here is, for example, one of the clauses in Article 22 actually said if you are going to file for a mark not for use purpose and you are actually hoarding the mark, that will be considered bad faith under the amendment. So as a result, the bad thing here is that one of the most important strategies when it comes to safeguard one's brand in China, the defensive filing strategy, would now be likely to be considered bad faith under the new law. So that's it, 10-11 minutes. That's a very short overview when it comes to bad faith filings in China and what you can do, especially under the new law, when your brand is taken in China. Follow us for more branding stories.